On behalf of National Law University Delhi and Project 39A, I welcome you to this event on judicial attitudes to the death penalty, primarily revolving around two studies done in India and in Bangladesh with former judges, former Supreme Court judges in India and trial court judges in Bangladesh. Project 39A is a criminal justice program at the National Law University Delhi, and our work started off with the death penalty, and some of you might have seen our Death Penalty India report, where we interviewed all of India's death row prisoners and their families and understood their socioeconomic profile and where they come and their interaction with the criminal justice system. We were then the center on the death penalty, and we transformed into Project 39A to broaden our engagement with the criminal justice system. We now do a lot of work on forensics, on mental health and criminal law, on legal aid, torture, and sentencing in criminal law. An interesting part of our work is also the Fair Trial Fellowship in Pune and Nagpur. In the central prisons there, in collaboration with the government of Maharashtra, we provide legal aid in collaboration with district legal service authorities to under-trial prisoners in those two prisons. So that's a very brief introduction to a wide arena of our work. Integral to that is also the pro bono assistance that we provide to death row prisoners based on the work that we've done. Over the years, we've represented about now about 105 death row prisoners in the Supreme Court and various high courts. We've managed to get 4 acquittals, 23 commutations, and we've lost 2 cases, one of which resulted in execution. So that's the broad area of our work and our interaction with the criminal justice system. And today, to discuss this issue, we have, and I know all panels say they're fantastic speakers, but it's a very eminent panel, very distinguished in their fields. Justice Gopala Gowda, and a former judge of the Supreme Court with over 20 years of judicial experience, first appointed as a judge of the Karnataka High Court in June 1997, was elevated to the Supreme Court in December 2012, and retired in October 2016. Of particular interest to us as part of this panel, because Justice Gowda was part of a bench in May 2016 that acquitted Adambhai Ajmeri and 2 others who were on death row for about 11 years in the Akshardham blast case in Ahmedabad. And while acquitting all 3 of them while they were on death row for 11 years, as I said, very explicitly noted that the police, then the investigation agencies had framed all 3 of them. A very, very rare judgment that has such very clear findings on evidence and not swayed by the nature of the crime and how the evidence is assessed. So of particular interest to this discussion today. Dr. Rahman is a professor of law at the Department of Law in the University of Dhaka, and has led the fantastic study that was done in Bangladesh in very, very difficult circumstances, as some of you might know. And it was great seeing how the study was done and the kind of interesting similarities and challenges and the differences in challenges in the studies that we did here and the study that Dr. Rahman did. So welcome to Bangalore and to India. It's very kind of you to come down for the event. Thank you. Professor Carolyn Hoyle is amongst the world's leading criminologists and has been at the University of Oxford since 1991, and the director of the Center of Criminology between 2012 and 2017. I'm sure many of you have read all the excellent work that she's done in her career, so I'm just going to leave it at that, and assuming that if you haven't read, you really should go and look up her work. Saul Lehrfreund brings over 30 years of experience defending death row prisoners in various parts of the world, including Southeast Asia, African jurisdictions, and the Caribbean. Co-founder of the Death Penalty Project UK, really one of the leading voices across the world on how the death penalty is administered and all the problems that exist in different parts of the world. And it's so striking, the similarities between these jurisdictions. Thank you, Carolyn and Saul, as well, for coming all the way and flying across the country to do these events with us. We really appreciate it. Thank you so much. A special note of thanks for my colleagues, Aishwarya and Nithika, who are here, and other colleagues in Delhi it's a first event for us in Bangalore, and thank you to the Bangalore International Center. We were a tad nervous as to whether anybody would show up, and it's great to see so many of you here today. We really appreciate your interest in our work. Thank you so much. Yeah. So what's going to happen now is each of us is going to just make some introductory remarks for strictly 10 minutes each and bring forth various aspects of this discussion. And then we'll obviously throw it open to discussion, right? The study that we did is available on our website, and I know some of you have got the copies, and we've run out of copies, so you can download it for free from our website. The study that we did was with 60 former Supreme Court judges who were in court between 1975 to 2017. That was a range. In that range, we could have potentially interviewed 86 judges who were there in court during that period. Of those, we have interviewed 60. 26 of them refused to be interviewed on various grounds. As you will see in the report, the names of even though the views are given, the names of it's not attributed to specific judges. What we have done is try to give you their criminal law experience or the judicial experience as rather than giving their names, because very often putting a name just makes it about very different things, right? And the entire idea of the study was to say, how do judges, former judges of the Supreme Court with the vast experience that they have adjudicating cases and the familiarity with the legal system, how do they look at the criminal justice system? What is their view of the criminal justice system? And given that view, what is their outlook to the death penalty in India, right? And in understanding questions, and we first started with asking their views on the criminal justice system, primarily to see how much of confidence was there in the legal system, in the criminal justice legal system. And towards that, we asked questions relating to fabrication of evidence, torture, poor legal aid, on sentencing. And it was very interesting that all the judges acknowledged the severity of the crisis, right? A vast majority of them. They acknowledged there was severe crisis points in the criminal justice system on how rampant torture was, on how Section 27 of the Indian Evidence Act is misused to plant evidence, and the poor quality of legal aid, and acknowledgement that it's the poor that often get trapped in the criminal justice system. So all those crisis points were acknowledged. But yet, when it came to the death penalty, it was fascinating to see that it was not like the judges felt that they were confident that the criminal justice system was working well and there was no issue, and that there were no fair trial concerns or rule of law concerns. Despite all of those concerns, right, you have judges showing a very high degree of confidence in the death penalty. And there the justification primarily was around issues of deterrence, right? And Carolyn and Saul will discuss their paper that they've written comparing these two studies, and to say that, and the assumption that they were testing, I guess, and was that if people had more information about the death penalty, that they would not support the death penalty, right? That was the hypothesis that was being tested, right? That flowing from what Justice Thurgood Marshall said in Furman versus Georgia, that if people were given information, that if people actually knew how our criminal justice system worked, they would not support the death penalty, right? And yet you have here, both in India and Bangladesh, individuals who are extremely familiar with the realities and the harsh realities of the criminal justice system, acknowledging that crisis points, yet coming out in support of the death penalty on a understanding that the death penalty will deter, right? And we can discuss that, what it means to put forth this argument of deterrence in the context of this crisis of the criminal justice system that has been acknowledged. What does it mean to say that death penalty will deter in a system like ours, right? And I think another thing that emerged really, and much has been written about this, is in the opinion study, is the complete breakdown of the rarest of rare framework, right? When we spoke to these 60 former Supreme Court judges of nearly about nearly 75% of them who had adjudicated death penalty cases, just the variation in understanding of what rarest of rare is as a doctrine, of what was laid down in this, in the majority opinion in Bachan Singh, just the variation must be of concern to us, right? That the doctrine has become so empty that it is capable of being filled with anything that individual judges want, right? And I think the concern, and I think we, as academics who think about the rarest of rare framework, what we haven't been able to really breach is this argument of that is somehow a part of judicial discretion, right? That this experience with rarest of rare since 1980 is inherent to the nature of judicial discretion. And we really haven't been able to unpack what does judicial discretion mean and what does it not mean. When does judicial discretion move into unacceptable levels of subjectivity, right? What are the parameters on which we can assess how judicial discretion is being exercised? And I think there's been very little thinking from legal scholars in India on that, and that has really set back the discussion on the death penalty. And I think it's really time to reassess Bachan Singh and say, what are the inherent flaws within Bachan Singh that is leading to this kind of wide subjectivity that we are seeing? In particular, if you look at death penalty cases, for every 20 cases that you can show that young age has been used to commute a death sentence, somebody else will show 20 other cases on the other side, right? Because there is no, for every 20 cases that you show me where a rape and murder of a minor has resulted in a commutation, because a judge has said that the state has not shown that this person cannot be reformed, there'll be 20 other cases on the other side, right? And I think a large part of that problem is that nobody has really discussed why does young age matter? Why does the poor socioeconomic background of a prisoner matter? Right? And that doctrinal foundation, that doctrinal coherence has just not been laid down, right? And therefore you end up having, and I firmly believe that the problem with the Bachan Singh doctrine is not just in judgments that confirm the death sentence. Doctrinally, even the judgments that commute the death sentence have contributed very significantly to the complete breakdown of the rarest of rare doctrine, right? And I think, and I'll just leave you with that thought. The last thought that I'll leave you with is, in terms of these elite surveys, when I say elite surveys, you mean in terms of people in positions of power who, within the legal system, acknowledge this crisis in the criminal justice system and yet support the death penalty. It leaves us with a rather troubling question of whether it is really deterrence that is driving it, or is it more leaning towards retributive justice, right? So I'll leave you with that thought, and I'm sure we'll have time to discuss many of the claims I've made, and I look forward to your questions. Now, if I may invite Dr. Rahman to reflect on the findings of the Bangladesh study with trial court judges. Dr. Rahman, please.
Thank you, Anup, and good evening to everyone. So basically, Professor Anup has summarized Bangladesh study as well, because all the findings that he has shown from Indian study equally applies for Bangladesh, except the breakdown of the rarest of rare framework, right? So nevertheless, I would just like to highlight few points about our study. This was the very first empirical study in Bangladesh on death penalty. So we interviewed 30 retired district and session judges. All of them had judicial experience of 25 to 35 years. And during that time, they exercised the jurisdiction of giving death sentence for 13 to 22 years. So we interviewed all these 30 judges. And we basically looked into 3 different areas. One is the procedural aspects of death penalty. Second thing was whether there is any sentencing norms and practices followed in death penalty cases. And the third area was judicial attitude towards the death penalty. So if I speak about the major findings relating to procedural aspect is that most judges, I will say that almost all the judges were just frustrated about the current justice system, current criminal justice system. They mostly said that this system is not working, and not working mostly because of the 2 criminal justice actors. One is police, and another is public prosecutors. So they are very corrupt, and they are too inefficient to administer their duties. And because of these 2 actors, there are many wrongful convictions, and also there are many cases of unwarranted acquittals, right? So judges basically blame these 2 agencies. And they also highlighted that torture is very routinely used. On the issue of torture, 2 judges declined to give any opinion. So we got opinions from 28. And out of those 28 judges, 25 judges said that it is routinely applied as a tool of investigation. And what is very frustrating for us is that 6 out of these 28 judges even justified torture. Some of the judges said that if there is no torture, then how will we run the criminal justice system? If the criminals are not tortured, then they will never confess their guilt. So this was a frustrating finding for us. And yes, our judges also talked about the problem of transplanting of evidence. They said that in many cases, prosecution just transplant evidences. And they also spoke about the poor quality of legal representation, especially for the disadvantaged accused. Because in many cases, they said that if a very poor person faces a charge of death penalty, it is very likely that he will not be properly represented in the court. So that was another point. In our finding, we have also found that Professor Anup was saying that rarest of rare doctrine has largely failed in India, arguably. But in Bangladeshi case, the situation is more difficult because we do not have any framework yet. We have found that in many cases, our Supreme Court is saying that death penalty should be the norm, death penalty should be the default punishment, and life imprisonment should be given only in case of exceptional circumstances. On the other hand, we have also found different cases where our Supreme Court has endorsed the rarest of rare doctrine. So there is inconsistency in practical sentencing norms. And there are also some, due to this discrepancy in practices, discrepancy in norms, we have found that sentencing is also just-centric. And this was confirmed by our retired judges. And I will revert back to this issue afterwards. If I now move on to the issue of judicial attitudes, yes, quite understandably, majority of the judges were in favor of death penalty. 19 judges were unconditionally in favor of death penalty. And mostly they justified death penalty on the ground of deterrence. They said that death penalty is the most deterrent one, and if we abolish death penalty, then it would be very difficult to control the crime rate. So this was their main arguments. And we have found 5 abolitionists as well. But the problem is that whenever the judges justify the retention of death penalty, they're speaking about the efficacy of the deterrence. But it is not proved. And in fact, there is no study in Bangladesh that proves that death penalty is more deterrent. Because we have also found some judges saying that life imprisonment is more deterrent even than the death penalty. So that is one issue, whether it is more deterrent or not. But what is problematic here is that most of the judges are speaking about the total collapse of the system. They are speaking about the problems of torture leading to confessional statement, and then confessional statement leading to death sentences. They are speaking about wrongful convictions, transplantation of evidence, right? So there are so many justice issues, but they're ignoring these justice issues and highlighting the utility issue, and that utility is also not evidence-based. So that was the main problem. And as I said a bit earlier, that death sentencing in Bangladesh has become as just-centric. To what extent it is just-centric, I can give you just a few examples. In our study, we have found that 28 judges, out of those 30, they handed down approximately 237 death penalties. And out of those 237 death penalties, one single judge awarded approximately 100. One single judge approximately awarded approximately 100 death sentences. And we have found that there are 5 abolitionist judges who awarded no death sentence in their entire judicial career. So there is a huge discrepancy in the figure. If we look at the 237 death penalty given by these 28 judges, we will find that more than 61%, that is 145 death sentences were given just by 3 judges. So out of these 237 death sentences, 3 judges given more than 61, and rest 25 gave the rest. We have found that there were one judge was basically in favor of de facto abolition of death sentence. He has, in his judicial career, dealt with almost 100 death penalty cases. And interestingly, he awarded no death sentence. But on the other hand, we have found another judge who claimed that in my judicial career, I have awarded death sentences in 75% cases decided by me. Right? So there is huge discrepancy and huge disparity in the actual death sentencing. So the major findings that comes from these arbitrariness in death sentences is that whether a person would be sentenced to death largely and mostly depends on who decides the case, rather than on the merit of the case. So all these findings comes from the opinion of the judges. But then again, when we ask about their opinion about retention or about abolition, they are in favor of abolition. They are in favor of retention. So their findings and their opinion in most of the cases do not match. So if I conclude the study, then I can say that yes, there are so many issues in favor or against it. But in Bangladesh context, this study shows us that justice would be best served if death penalty is abolished. Thank you.
Justice Gowda, you were a participant in the study that we did here in India. And I think we're very curious to hear, what do you make of this finding and what that this disjunct between the view on the criminal justice system and this confidence in the death penalty, and generally what you read in the report? What are your reflections on that process?
Dr. Anup Surendranath, Director of Project 39A and Professor of Law in Delhi Law School University, and my co-panelists, Justice B.A. Patil, sitting judge of the High Court of Karnataka, respected invitees, and my affectionate student participants. At the outset, from my bottom of my heart, I must congratulate Dr. Anup and his team having undertaken this great task of making a study, in-depth study, with regard to the death sentence both in India and in Bangladesh. It's a very, very important topic which is required to be debated and resolved either this way or that way, to see that civilized nation, what is to be practiced in the name of administration of justice to bring home the guilt of the culprits. My experience at the bench over a period of nearly 20 years, the Indian judicial system, particularly the criminal justice system, miserably failed. Right from the assistance to the courts, at the stage of investigation, there is a faulty system prevalent in India. The judicial attitude towards these is very, very minimal. We are not taking note of the fact that investigation starts from the police station, not independently, not competent persons. This you can see from the initial stage of investigation, from registering the FIR and starting the investigation process. Most of the people are ignorant of the criminal jurisprudence principles, and they will not be knowing what is the mode of investigation. We are seeing very recently, last 3-4 weeks, how investigation is going on. I don't want to make and traverse that area. I only pointed out how the investigation will be done by the incompetent persons, investigation at the instance of the vested interest people, investigation at the instance of diverting and making use of the machinery for the other ends to achieve their object. This is another aspect. the investigation part is most important for the purpose of bringing home the guilt of an offender. Now we are on the point, very, very relevant topic which is required to be debated in the national level, and we must bring home the point to the legislature. Either they must amend the Criminal Procedure Code, either the capital punishment must be there or it should be abolished. If the capital punishment is there, judicial discretion is left to the judges, then we are required to examine how the judicial attitude in the absence of the sentencing policy framed in the country, how judges from different backgrounds, the social status, their attitude, their economic status, their mindset, their thinking, without knowing the human rights aspect, only in their mindset that before them, either before the High Court, the first trial court, the appellate court, and in the Supreme Court, concurrent finding and 136 petition, whether for concurrent finding to be examined or not, without going into the details, evidence of the matter and law on the question. What is law? Law is laid down in particular with reference to that case. In my experience, on the bench in Supreme Court, he has referred to the judgment which I decided along with Justice A.K. Patnaik. Concurrent finding is the argument, the appeal of the prosecution, appeal of the accused persons before the Supreme Court. Appeals were pending there. The state appeals, they wanted to impose death sentence to the remaining persons who have been inflicted the life imprisonment. I have recorded a categorical finding in the judgment on evaluation of the evidence on record with reference to the charge and the factual situation in that case that most of the people have been falsely implicated. The 3 investigation officers have changed in that case. That is the scenario in India today. The investigation officers, to their whims and fancies, the investigation will be made. I am, with all seriousness, I am telling to this august audience that the criminal justice system miserably failed. This is a very important aspect of the matter required to be taken note of for the trial judges, first appellate court judges, and more so in the Supreme Court. Supreme Court 136, merely because no concurrent finding, throw it away. No, I don't agree, because I tell you, I have recorded the finding. Concurrent finding is erroneous in law. I can show, I must have seen thousands of criminal appeals before me. I have examined, rightly pointed out, the torture, the confession at the instance of the police officer in the police station without mentioning the name, the date, the time of the arrest of the arrestee, the accused person who is alleged to have been indulged in the crime. The confession statement will be made. They say, at his instance, the weapons are recovered. He will not be stated, he or she will not be stated. The stock witnesses, they will draw the mahazar and they will examine. And if you see the weapons recovered, the recovery, that is admissible under the Evidence Act, Section 26. It is not extrajudicial confession if it is recovered at the instance of the accused person. That is the shelter, protection to the investigation officer. So that is made use of. These people plant the weapons and the objects which are used, alleged to have been used by him, recover it, and evidence that will be placed on record, whether it is probable or not without examining it, blindly, the judges will accept it with great respect to them. This is what I noticed in the case of Akshadama case. Concurrent finding. So concurrent finding should not be the criteria to examine, reopen and reappreciate evidence. So judicial attitude, because the reflection of the social mind. The moment he is involved or he has been made an accused person, judge should be, as rightly pointed out, a fair trial. He should not have prejudice. An accused person or a convictee has got fundamental rights. And we have to examine carefully. We should not arrive at a conclusion. He is an accused, he must have committed the offense, charge. Against the charge, there is a serious charge against him. To arrive at that conclusion, what is that evidence? That evidence is positive evidence. That evidence is direct evidence. That evidence is circumstantial evidence. That evidence is probable evidence. It is natural to believe. There, the mind is blocked of a judge. This is what I noticed. This is very important. If he is really a culprit, there must be evidence. The benefit of doubt concept is there. You can acquit 10 persons on the ground of benefit of doubt. You shall not convict one person on surmises and conjectures. Or some evidence. Some evidence is not sufficient in criminal jurisprudence, criminal trial. There must be cogent evidence in support of that charge, and that evidence must be probable evidence to arrive at a conclusion. So I am on the point. The judicial mind, first the investigation faulty, that will not be examined by the judge. Judge will go on the basis of evidence which will be placed on record. So therefore, the judicial attitude today in India, their background, social background, the economic status, the mind psyche is required to be examined by the appellate court and the first appellate court, second appellate court. I have seen any number of cases that lack of evidence, no evidence, finding will be recorded on the charge. Don't be under the impression that I am telling all these things. I have been branded that is a pro-labor judge. I have been branded is a pro-tenant judge. I have been branded is a liberal judge. Nonsense. This should not be the attitude. I am neither a liberal. It is not the question of liberal or pro-labor or pro-tenant. You are a judge. You are required to examine the facts, evidence and record. I have also convicted people. I have convicted people. I have acquitted the people. I have given relief to the people. I have been named as a people's judge. Yes, everybody must be people judge. What is wrong with that? It's not the people judge or the pro-convict judge or pro-acquittal judge. Judge's job is to examine objectively with great respect to all my brethren and sisters and judges who were sitting, I tell you, mind-boggling things we are doing. Mind-boggling things we are doing. Sorry, Mr. Patilji, kindly excuse me. I am not attributing any allegation to anybody. It is the system I am pointing out. I am pointing out only system. Don't mistake me. I have got great respect for you. You are one of the finest judges in the Karnataka High Court, I know. I'll tell you, yesterday, physically disabled person's son, they came to me with a bundle of papers. I'm telling you to show and substantiate my presentation that the police have gone to the extent of fabricating in 75% of cases. The classic case yesterday I have seen, murder case. Murder case of a doctor. The accused is in northern side of Bangalore. The deceased is in South Bangalore. The distance is more than 30 kilometers to that place. The offense had taken place at 2:30 p.m. That fellow, the accused now, who is facing the trial, is a tenant of the deceased, the house which is situated in northern part of Bangalore. The theory of the prosecution is, wife, immediately after 4 hours, she has given a complaint. Somebody came, knocked the door. I opened the door. He wanted to talk to my husband doctor. He was sleeping in the room. Then I told him somebody came to talk to you. He came. Then he immediately took the wooden table which was available near the TV set. He had hit him and bleeding was there. He fell down. Then he caught hold of his shirt, and his shirt, the accused shirt, was left there. He went away. Second day also, she has narrated the same story. If he is a tenant, she should have told so and so. Afterwards, this shirt is the basis on which these police people falsely implicated him. On the basis of this, the trial court granted bail. That was subsequently cancelled. It was taken up to the High Court. During pendency, bail application. I'm telling you, this man is a tenant, who is a poor man. Father is a physically disabled person. He is inside the jail. For livelihood of a family, they are suffering today. How can we expect him to defend spending lakhs of rupees? So this is a classic case where the police are falsely implicating the accused person in number of such cases because they fail to investigate to find out who is the real culprit. If the murder has taken place, case has to be registered. If case is not registered, what will happen? Now what happened? I don't want to go into the details of all these things, what is happening for the last 2-3 years. The great intellectuals were targeted and killed. Investigation still going on to trace the victim. So this is the level of efficiency of investigation in the criminal justice system in India, and same thing is reflecting in the courts. So this is the very, very, very bad trend. Now, question is, in a civil society, civilized nation, capital punishment must be there or not? If the capital punishment is there, what is the outcome of it? If the capital punishment, according to some of the people's understanding, it is a severe punishment is there, the offense rate will come down. Where is the offense rate has come down? 1,260 from 1953-63. The crime is increasing today. Crime increase is nothing to do with the punishment. So that area is required to be attended by our the governors. The economic background of an accused and the social background of accused are all relevant. Don't be under the impression that a criminal is a born criminal is committing offense of robbery and dacoity. Today, robbery and dacoity is also intellectual, highly educated people are indulging. You must have read. Engineering students, unemployed people are indulging in snatching up chains early in the morning because unemployment problem is there. So these are the areas which are required to be addressed by the politicians. Therefore, in this background, next meeting, I suggest to you, not only the judges, the professors, the psychologists, and the police officers you must invite, the bureaucrats you must invite, the legislators must invite, a full-fledged debate must go on. We must hear their views and we must present our views. I am on the point. Am I for a retention of the capital punishment or abolition of capital punishment? I am telling, having regard to the existing situation which is being prevailing, and the death sentence is only to the vulnerable people and the poor people who are executed, not the big, the murderers and terrorists are not hanged. Please understand. Today, as rightly pointed by Professor Bangladesh, legal aid, today I told you that person, you must, if you want to engage a lawyer, there is no livelihood for him. If you want to engage in terms of lakhs, if you want to go to Supreme Court rejection of the bail, who is languishing in the jail, you in terms of the filing of charges itself 1.5 lakh. It is not possible. So therefore, effective lawyers to defend them is not there, despite equal justice and legal aid under Article 39A. That's the concept which is there by 44th Constitutional Amendment, but that is not materializing. So therefore, I am advocating that people, all concerned, the legislators, intellectuals, the juries, the judges must think loudly in regard to the alarming situation. Innocent people are being executed. Death sentence. Innocent people are life imprisonment. I am not saying all the convictions are bad. No. Majority of the cases are like this. So therefore, I am of the view that the reformative theory for which we are completely wedded, what is the reformation taking place in the jail? Nothing is taking place. So reformation is not possible. Reformation is possible provided if you take up and do properly. That is not being chalked out. So I am of the view that in a civilized nation, retention of death sentence, having regard to these all circumstances which is prevalent in the country, should be abolished. And instead of that, life imprisonment is not 14 years. Throughout his life. If that is imposed, that will work out. There is also very severe punishment. The argument of the other side, retention is people, that capital punishment must be retained in the system, in the country. If you give life imprisonment, Influential people will get commutation. They go to the state government, the state president of India, they get commuted. I am of the view that kind of thinking, who can do that? Only affluent people can go there. Not vulnerable people can go to the governor and get commutation. So the punishment of severe nature of life imprisonment is sufficient. Yes, what is happening, as rightly pointed out, rarest of rare cases. Rarest of rare cases principle, what a great judgment pronounced by the Constitution bench way back in 1980, Bachan Singh case. Entire the constitutional philosophy with reference to Part 3, not only the judgments of the Supreme Court of India, judgments of America, judgments of different countries have been examined. Great juries principle, the thoughts have been taken into consideration. Rarest of rare cases, what is the reason you are giving? Yes, rarest of rare case is double murder, triple murder, the rape and killing. Yes, correct. They are all rare. They will come under rarest of rare cases. But rarest of rare cases for imposing the death sentence, you are required to examine the mitigating circumstance of the accused. What is the mitigating circumstance? What is the mitigating circumstance? Mitigating circumstances, I'll tell you, I have not seen any evidence adduced on behalf of the accused. In the absence of evidence, the court is asking, please adduce evidence of mitigating circumstances. This is a serious matter. Prosecution is asking for death sentence. Please adduce evidence. Where is the evidence? There is no evidence. What is mitigating circumstance? Also stated in Bachan Singh case, reiterated in Machi Singh case, paragraph 32. For want of time, I am not in a position to read all those mitigating circumstances. So mitigating circumstances may be any number of mitigating circumstances, but there is no evidence at all. In the absence of evidence, where is the question if you have examined the mitigating circumstances, impose a death sentence? This is the imposition of sentence. So therefore, to conclude my viewpoint, I am for abolition. Abolition is there, more crime is not the correct, the position, factual position. More crime because of unattending the problems which are confronting to the people of the country. So therefore, if the property is there, there will be a crime. Woman is there, there will be a crime. But you have to develop culturally. What is the program of the government? No policy at all. For youth, what is the program? For the woman, what is the program? For vulnerable section, what is the program? To culturally examine them. Unemployed, what is the program? So crime rate, wherever the property, wherever the power, wherever the woman, wherever the officers misuse, it will be there. So therefore, increase of crime rate is not on account of imposition of death sentence or not imposing death sentence or life imprisonment. It is, the issue is differently to be addressed. Therefore, I am of the view that I am not for retention, I am for abolition. Thank you very much.
Thank you, Justice Gowda, and I really hope that more judges had the intellectual honesty that you have displayed both on the bench and after, in the manner in which you have analyzed these issues and confronting the realities of our criminal justice system. So thank you for that really refreshing set of thoughts, and it's so great to hear that from a Supreme Court judge. Thank you so much for your comments. Carolyn, if I may request you to reflect on these contradictions that emerge from both the Bangladesh and the India studies and what it means for all that we thought about the death penalty. Yeah. Thank you.
That works. Thank you for coming, and thank you, Anup, for inviting me. It's very interesting to compare two countries like Bangladesh and India because in many ways they're quite similar. They've had similar economic progress, similar increasing rates of literacy, and similar declining rates of crime and conflict, particularly since the 1970s. And yet they've diverged somewhat in terms of the death penalty. So while the rarest of rare doctrine has progressively restricted the use of the death penalty in India, and there are fewer executions, many fewer executions and death sentences. In Bangladesh, these continue at a higher rate, certainly, despite quite comparable murder rates, especially from the 1990s onwards. Also in India, you've seen the presumption in favour of life has developed in the evolving jurisprudence of the court. Whereas in Bangladesh, as Mahabub said before, there is this emerging presumption in favour of death, except in extenuating circumstances. So to get these two projects, both of which I was involved with somewhat at the beginning, or from the beginning, and compare the data that's emerged from them and see incredible similarities in what was found is very exciting for me. One of the things I want to just tease out some of the emerging findings, some of which you've heard about already this evening, but I want to bring them together and say what I thought was particularly interesting. And the prevalence of torture in police custody was surprising. What you see here is some of the quotations from both of those reports that make clear that confessional statements are very often the product of custodial torture. And I don't just mean psychological torture, I'm talking also about physical torture, people being severely beaten in police custody. That's surprising in and of itself across both jurisdictions. But what was particularly surprising for me is that in both jurisdictions, the same proportion actually of judges, given that there were 30 Bangladeshi judges in the sample and 60 in the Indian sample. So 6 of them in Bangladesh, 12 of them in India, found some ways of articulating a justification for torture. This was not a justification that they liked the idea of torture. They certainly didn't. Don't misunderstand what I'm saying here. But they understood it in the context of a severely compromised policing process with inadequate or incompetent policing, under-resourced policing, and therefore the recourse to torture was seen as almost inevitable, a way of dealing with a system which is ineffective and inefficient. There's this nice quote at the bottom: the police are either too lazy, they don't have the manpower, they don't have the methods of scientific investigation. So these utilitarian justifications for what many of us would regard as intolerable behaviour, and certainly offends international law as well as national law in both of these two jurisdictions. If you have police incompetence, if you have police torture or any breaches of due process, what you really need is a good lawyer. And yet in both jurisdictions, comments were made by the judges suggesting that they felt legal representation was inadequate, that it was incompetent defence. Too many stories we heard across both studies of lawyers either not turning up in court and sending their junior, which may be fine for a traffic violation, but is not fine if somebody is facing a capital charge. And also not preparing and talking to their clients before they go to court, not preparing sufficient mitigating evidence, etc., etc. The Bangladeshi judges in particular were just as concerned about prosecution lawyers, as we heard before, that they were incompetent, or in this lovely quote here, that they were evil, because what the judges were worried about here was wrongful acquittals. People getting off very serious charges. Don't forget, we're talking about capital charges in these two jurisdictions. Unlike others such as China, we're talking about heinous crimes, murders typically. So there was concern about legal representation. Now, if you have a system where people are convinced that the policing is inadequate and the legal representation is inadequate, what you get inevitably is wrongful convictions. And sure enough, the judges on in both of these jurisdictions expressed deep concerns about wrongful convictions, but also expressed the view that they were fairly prevalent. They were also, as I mentioned before, concerned about wrongful acquittals, the other side of the same coin, really. And so they explain these wrongful convictions in terms of the policing and legal representation. In other words, poor due process protections in pretrial processes. So, if the pretrial processes are poor, what can we make of the trial? Well, as already been said by everybody on the stage so far, there is a great deal of confusion and arbitrariness in death sentencing. So there's too much of a priority given to aggravating features of the crime. And some judges understood the rarest of rare in terms of crime categories, which of course it's not really just exclusively about the type of crime. But they would give examples, particularly heinous rapes or sexual murders of young children would be a category that they would have thought elevated something inevitably to the rarest of the rare, regardless of potential mitigation or regardless of potential to reform. So, as I said, undue weight given to the brutality of the crimes or the heinous nature of those crimes, and also to the vulnerability of the victim. And I'm not saying that's irrelevant, but it shouldn't be a key factor in sentencing in these cases if the death penalty is on the table. Mitigation evidence, there was much less focus on that. So aggravating factors trump mitigating factors in these cases. And indeed, some judges express the view that where you have a capital offence, where you have this kind of heinous crime, the mitigation is actually irrelevant. Again, it shouldn't be irrelevant. Similarly, some people felt that if the crime was so very serious, and these will be serious crimes, that the prospects for reform could be deduced from the serious nature of the crime. That's mixing up offender-related variables with offence-related variables, which should be separated out in consideration of any sentence. And finally, if you read the Batch and Singh judgment, which established the rarest of rare, it's absolutely clear that the public opinion should have no role in sentencing death cases, whether or not you think it should in other cases, which I don't, but certainly not in these cases. And yet, for some of the judges, they expressed a view that the collective conscience was an aggravating factor. It's already been mentioned, but it's worth repeating, I think, because it's so very important. And in both of these studies, it became very clear from analysing the data that judging is very judge-centric. So the personalities of the judge, the background characteristics, socioeconomic status, even religious beliefs of the judges, and certainly whether they're pro or against the death penalty, affects sentencing. And you get these rather wonderful quotations. I particularly like that final one because we were in an event in Delhi on Tuesday that Anup very kindly arranged, and the lawyer sitting with us on the panel said more or less that last quote. If so-and-so is hearing my case, I'll end up hanging from a rope, but if someone else is, I'll live. In other words, lawyers get a sense of who they're going to be before, and therefore what the likely result of a sentencing deliberation will be. So I think this raises the point that you can have a doctrine such as the rarest of the rare, but if you don't have clear and coherent sentencing guidelines, and if you don't have adequate training for judges on how to apply those guidelines, you're going to get arbitrary, confused, mixed up sentencing, which really ends up being about the judge sentencing rather than about the aggravating, mitigating factors of the case and about the ability of the defendant to reform. Now, neither of the studies went out to ask the judges if they were in favour or against the death penalty. So these findings are somewhat difficult to interpret, but the opinions of the judges emerged in the interviews and sometimes emerged quite strongly. And so for the majority of those judges interviewed across the two samples, which gives you a sample of 90 in total, it became very clear whether they were what we might term abolitionist or retentionist. And exactly the same proportion of judges in both studies were retentionist. I think it was 80% in India and 79% in Bangladesh. So we have to start thinking, why do they hold these views, and what is informing them and what is not informing them? Anup mentioned before the Marshall hypothesis, and it's a very interesting hypothesis that emerges from the Furman versus Georgia case. That's the American case from 1972, which imposed a temporary moratorium on the death penalty in America. And Justice Marshall in that case opined that people are supportive of the death penalty because they simply don't know how it's used in practice. They don't understand how it's administered. They don't know the inequities. They don't know the unfairness. They don't know the deep flaws in the processes that lead to a death sentence. And if they did, they would soon consider the death penalty to be immoral and therefore unconstitutional. So for him, knowledge was everything. And I think Saul's going to talk a little bit about that in public opinion research. But it was very interesting that a strong paradox, as Anup put it, and he's absolutely right, emerges from these studies, that despite knowing the inequities, the unfairness, the breaches of due process throughout the system, most of these judges, 4 out of 5 of these judges, were strongly in favour of the death penalty. Now, while the abolitionists, of whom there were only 5, had principled objections to the death penalty, human rights objections to the state's coercive power and ability to kill people, the retentionists were not influenced by and large by retributive rationales. Only 5 of them were. They were influenced by deterrent rationales. So the quotation here sums that up nicely. They thought that in these types of cases, the death penalty would deter potential offenders from committing serious offences. So no support for the Marshall hypothesis. So to wrap up, these studies raise serious contradictions about how we think about the influence of knowledge on people's views of the death penalty. So despite the fact that the judges had knowledge about this flawed process, they were trusting in the potential of the death penalty to deter offending behaviour and to realise other sentencing rationales, but deterrence was the key one. So unlike the public opinion work, Marshall's hypothesis is not supported here, and we think it's interesting to try and do some more elite opinion research in other jurisdictions that retain the death penalty to see how that plays out there, see what factors might be different and what factors might be similar. So this utilitarianism around deterrence is really what was motivating these judges. And if I just conclude with one line, it would be that I think the next project has to be some way of disabusing judges of this deterrent fallacy. Thank you.
Thank you, Carolyn. And it really is mind-boggling is the word, right? I mean, and ever since I've read the conclusions of our study and Dr. Rahman's study, it just shows us the intensity of the challenge to bring the death penalty to an end, right? Because what is driving it is clearly something, it's almost scary to think that what is driving it is beyond reason, right? And I think the only question that left me with was after reading the draft of your paper, whether elite opinion studies and public opinion studies might work out differently on when you supply information to a general public, the kind of studies that Dr. Maisato has done. When you supply information to the general public, that they might tend to change their opinion, which does not seem to be happening for elites and seem to be a lot more resistant to changing their views. Maybe something to explore in the future as well. Yeah. So that brings me to Saul. Saul, in terms of you've been involved in elite opinion studies and public opinion studies. It would be great to just hear your reflections on why are these important, what are they telling us, and what is their strategic role in death penalty litigation and advocacy across the world.
Okay, thank you, Anup, and good evening, everybody. Okay, so just very briefly, our organisation has been confronting the death penalty for the past more than a quarter of a century, And during that time, we've worked in more than 30 retentionist countries. And I'd say that without exception, in all of those 30 countries, we are confronted with one of the primary justifications for retention is that the public support the death penalty. So wherever we go, a government will say we can't abolish the death penalty because it has such strong public support. So many years ago, we thought, well, let's challenge this assumption. And the way to challenge it is to instruct criminologists and sociologists and academics to conduct independent public opinion studies, trying to get behind the headline figure in terms of support of the death penalty. And what's been so interesting is in more recent years, as we've seen in India and Bangladesh, and Carolyn's doing a study of elites in Zimbabwe and also in Indonesia, and we're doing one in the Caribbean at the moment, is that there's a big difference between the findings of when one looks and analyses public attitudes as opposed to elite attitudes. And the Marshall hypothesis that we've spoken about really seems to apply to the public rather than the elites, who seem very firm in their opinions, whereas the public, as we'll see, their opinions are much more, I'd suggest, superficial and malleable. So if you start from the sort of broad proposition that the majority of citizens, and I think this would be fair to say in nearly all countries, the majority of citizens, in abstract at least, will support capital punishment. And we'd say for a number of reasons. One, it could be that they're conditioned, socialized to accept the death penalty. It's been the normative punishment. So for them, it's just part of their language, part of their culture, legal norm, is we have the death penalty, we've had it for many years. And secondly, we'd suggest that often the public will base their views on capital punishment around misconceptions and misunderstandings of the death penalty. Their support for the death penalty is predicated on the view that there aren't wrongful convictions, that there isn't inequity in the application, there isn't discrimination, and there aren't wrongful convictions. So that is the assumption that the public have, that the system works and the death penalty, therefore, that's why we have it, and that, therefore, is a good thing. So we challenge these assumptions, and that views may change if people are able to make a much more informed appraisal of the evidence. So public opinion surveys now, we've been involved in a number of them, not all of them. They've been conducted in Japan, in China, in the Caribbean, in a number of African jurisdictions, in Belarus, which is the last European country to retain the death penalty. And what's so interesting about all these studies, a bit like India and Bangladesh, is the findings are pretty much the same across the globe. And the large numbers of surveys, they all follow a similar model. They try to assess, first of all, the strength of support, not just the size. So it's not just do you support the death penalty, but how strong is your support for capital punishment? And once you assess strength, you get very different answers to a superficial yes or no. The binary yes or no doesn't really unpack the question of public opinion. We also ask people, or we try to inquire whether these opinions are based on sound knowledge of the system. So we ask people we try to inquire as to knowledge levels, interest levels, concern levels in the subject matter. And thirdly, and this relates to the studies we've been discussing today, whether people change their views when they become aware of information about the ineffectiveness of the death penalty as a tool of criminal justice, the fact that it doesn't have any extra deterrent value. And secondly, the possibility of mistakes, unfairness, unfair trials, and wrongful convictions. And the results are pretty astonishing. So there's too much data, there are too many studies, so I'll just cherry pick a few stats just to make good these points. So just first of all on knowledge. So how much knowledge do the public have when they make these decisions? And all the surveys invariably showed very low levels of interest, concern, and knowledge in capital punishment to the general public. And these are big samples. China was 4,500 people, Malaysia was more than 1,500 people. Trinidad was over 1,000 people. These are representative samples. In China, only 26% of the sample said they had any interest at all in the death penalty, and only 3% of the sample were very interested in the death penalty. In Malaysia, 36% of the sample were not very interested in the death penalty. Knowledge, in Malaysia, only 6% claimed to be well informed, 53% claimed not to be very well informed. And in Japan, very interestingly, the researcher Maisato surveyed 535 people, and she put to the sample 7 facts about the death penalty. Only 2 members of that sample, 2 people out of 535, said that they knew all about those 7 facts. So then it raises another question of how relevant is public opinion when it really doesn't know very much about the subject matter that it's being questioned upon. But critically for today's conversation, what about the impact of information? Going back to the Marshall hypothesis, does giving information to the public shift people's views on the question of the death penalty? And we've seen very clearly from the studies in India and Bangladesh this incredible paradox where people who not only have knowledge, but they have a working understanding of the problems of the criminal justice systems, this didn't impact on their views on the death penalty at all, or hardly any impact whatsoever. But what about the public? Do the public's views change when they're provided information? And throughout all of these surveys, there are now 9 or 10 of these surveys across the globe, there's very strong and consistent evidence that emerged that support for the death penalty rested on the belief that it was administered without error. And that is consistent in all the surveys. And in China, Trinidad, Malaysia, and Singapore, just to spread it around the globe, the respondents were asked if they'd still favor the death penalty if there was evidence that innocent people could be sentenced to death and executed. And in China, support for the death penalty fell from 58% to 25%. In Trinidad, from 89% to 35%. Malaysia, 91 to 33%, and Singapore, 92 to 35%. And very similar data emerged from Ghana and Trinidad. So it really is proven that the Marshall hypothesis works with the public. It doesn't seem to work with elites, but it really does seem to work with the public. That if you tell the public the truth about the administration of criminal justice in capital cases, support for the death penalty withers. It diminishes very, very quickly. So it's just a very interesting area. And I think that deterrence studies in India, Anup, will be very important. I think public opinion surveys in India would also be very revealing. And I know there's a lot of fear about public opinion surveys, and we've always been nervous about conducting them. However, I think now we should feel confident based on the results from all of the various surveys in all these different countries, different cultures, religions, backgrounds, that the results are comparable. And it really defeats the primary justification of retentionist governments that you have the death penalty because the public support the death penalty. The binary yes or no does really not get to the bottom of the problem. And ultimately, abolition or retention is based on sound knowledge and principle, not on either individual views on deterrence or assumptions about the system working perfectly. So I hope that adds a little bit of flavour to the conversation, just looking at different opinions and attitudes. Thank you.
Thank you, Saul. I remember hearing you speak for the first time, and that fascinating example that I keep repeating from then is that example that you gave of if you ask people generally, do you support the death penalty or not, you're going to get very high numbers of people saying, yeah, I do support the death penalty. But that example that you then gave, that if you said, rank the following measures in terms of their effectiveness to address sexual violence, and you give better policing, better law and order, better education, and you put in death penalty there as one of the options, that the death penalty invariably receives a very low rank, right? And then that tells you so much about supplying of information, how you ask questions, and to be very careful about public opinion surveys, that it's not just about going out and asking 5,000 people, do you support the death penalty or not? Because you're then going to be saddled with a bigger problem, right? But yes, I see the potential and the excitement of public opinion studies. And you're right that we've been nervous about it because I think we have enough problems to deal with on the death penalty. But I think the dichotomy between public opinion studies and elites might open up a window into more strategic questions of that just relying on courts as a strategy might not be too wise a way forward. That we often underestimate the value of meaningful public engagement on this. We always think it's tough, it's messy, and therefore try to avoid that. But maybe these studies are showing that there's a need to revisit that kind of wisdom on that. So,
can I just respond two things? I mean, by analogy, if, for example, a country would be crazy enough to have a referendum on whether you should be in or out of the European Union, why would you do that? Secondly, a lot of the public opinion work is now being used as evidence before courts. So courts are very aware that public opinion, first of all, public opinion shouldn't determine constitutional questions. But just to avoid any doubt that if a judge was minded to refer to or think that public attitude should determine the question, then it's important to present the evidence to say, well, actually, it's not black and white. Public opinion, I mean, the ultimate answer about public opinion is it's grey and it's complex, ultimately.
okay. So on the basis of those very interesting perspectives, I'm happy to take a few questions. I know we said we'd wrap up by 7 and it's a minute past 7. So if I may please request you to just give your name when you ask the question. And if you're comfortable giving your institutional affiliation, please do so. But may I request only one thing? Even if you want to make a comment, that's fine. But I'm just going to keep it very strictly to about 90 seconds to 2 minutes, and I'm just going to ask you to stop. So I hope we can respect that. We can start with a question here. Yeah, I just come. Yeah, and we'll take about 3 questions together.
I'm not sure if I'm pronouncing your name right, but may I say Lehrfreund? You brought up this.
Your name and
Manmohan
yeah.
is my name, Manmohan Reddy. You brought up this question about European Union, but you didn't answer it. And it's very similar to the kind of examples that you're giving with respect to the death penalty. Would you like to answer that question, the Brexit question? Not in terms of yes or no, but in terms of how it could have been framed intelligently for people to understand. I would say it would have been virtually impossible.
The question at the back there.
One issue which is probably not exactly Jairam. Relevant to this particular discussion is the main thing of victims' rights, because the retentionist crowd, their main argument is, what about the victims or survivors? Don't they have rights? So I think that has to be addressed, and I think Professor Carolyn Hoyle or Lehrfreund and yourself, Anup, could do that. Thanks.
Yeah. Right there. Nitika, right there.
Yeah, so my question is, my name is Aishwarya, and my question is, if people are made to be aware that the criminal justice system is faulty in nature, and they are made to convince and believe, they believe that the distributive justice is how we perceive it in terms of how our constitution perceive it has failed, is it possible that they might even lose faith in the constitution and the system itself? And could that be something of concern for us as legal scholars?
Saul, do you want to take the question on the difficulty? I will just take 3 questions and come back. The difficulty in framing referendum questions, right? And therefore, I mean, I guess the larger question is there that inherent danger of asking the wrong question and therefore getting the wrong answer?
Yeah, I mean, Brexit, I mean, we don't really like talking about it. It's so depressing, but it's actually quite helpful in this context, because just a few points about it. I can't really answer the question in full. It's so complicated. We'll be here forever. But I'd say, first of all, people just didn't have accurate information to make a decision, okay, number one. And we know that now. So what we know 3 years later is very different to what we knew 3 years ago. I think the second point is people didn't vote on the European Union, they voted on other things, okay? They voted on their own issues in their own lives. So referendums, people go away, they deal with their own fears and their own personal situations, so it becomes quite subjective, even though it's about a broader issue. I think the other point that you answered yourself was it's almost impossible to frame the questions properly. And I think the third point, or the fourth point, is it's really not a question for the public. The public don't have the tools to answer that question. It is far too complicated, nuanced. That is why we have representative government. And that, I think, is the analogy to the death penalty. If you look at abolition of the death penalty, which has taken place in I'll get the numbers wrong, but 114 countries in law, in none of those countries has the death penalty been abolished by referendum. It's been abolished by government through leadership, principled leadership. If it had been left to the public, the majority of those countries most probably wouldn't have abolished the death penalty. But having abolished the death penalty, people readily and quickly accept abolition. It doesn't come back. The question goes away. So, I mean, I suppose the answer is that referendums just don't work. For me, they don't work, and they become very divisive and cause more problems in society in the long run. So that's why you need leadership on these particular questions.
If I may just request Carolyn and Justice Gowda to respond to Jay's question on victims. That very often a very strong justification, as Jay was saying, was that it said that victims get a sense of justice if the punishment, if the death penalty is available, it is given. The victims want it, and the victims feel a sense of closure, or that the state has done right by them. So you just reflect on that argument of victims' rights and the death penalty.
Should I start on the sort of more theoretical work, and then you can tell us what it's like in practice, maybe? Thank you for the question. I started my life as a victims scholar, so it's of interest to me. I think too often victims' rights are sold as a zero-sum game. By that I mean that you're either for victims or you're for defendants. And I think that's a false dichotomy. I think it's just plainly wrong. But because of that, politicians, various other people in the criminal justice system too, use victims to ratchet up punitive sentencing, and I think that's dangerous. I think the academic research on the death penalty and the victims is poor. There hasn't really been enough done to establish any relationship between the death penalty as opposed to life sentences and victims' rates of satisfaction, or what is being called in the literature closure. I happen to think that if you lose a loved one through murder, you probably will never get over it anyway, regardless of the sentence, but that's a slightly separate point. What the research on victims suggests is that what they want is information throughout the process, not to be excluded from the process. And some victims want a role in criminal justice. They want to have a say, they want to have the say in court, they want to make a victim impact statement, for example. There is no evidence that if victims don't get the death penalty, they will be less satisfied than if they do. And what we also know about jurisdictions that have abolished the death penalty is that victims will then clamour for the next most serious penalty available. In other words, if you want justice for your loved one, you want the court to impose the most serious penalty it can. It doesn't matter whether that's the death penalty or a life sentence or life sentence without parole, or even if it were a very heavy fine, which you might find in Saudi Arabia if you're a victim of murder, for example. They just want the most serious penalty. So they want a sense of justice, but justice doesn't have to equate to the death penalty.
Professor Carolyn said it from a theoretical perspective, and I can just give you a very recent example. This is a case now going on in Bangladesh. It was discovered in this month only. The background of the case is that back to 11 years ago, a 9th grade student was missing from home, right? So there was a GD filed in the police station. So there were some public opinions, hues and cries that this person should be found out by the police and so on. So police ultimately could not do anything. Then the investigation was handed over to our specialized agency, CID. They took up the investigation, and within few months, they arrested 4 persons and registered a case for murder. They were taken into remand for 1 week. And after 1 week, all 4 gave confessional statement. All 4 confessional statements, they implicated themselves, and they corroborated the co-accused confession as well. Then the trial started. Trial is at the very end stage now. And in this stage, the victim has appeared. Victim has come. He was not murdered. He voluntarily just escaped his house because of the pressure of the study and other things, and took a job in a remote district in a workshop, and he was not traceable for 11 years. Now he has come back. Now, if he did not come, what was the result? Invariably, the result was death penalty, right? And if this boy, if he came after 10 years, then there could have been an execution, right? In that case, there is a victim for justice, there is justice for the victim, justice for the society, but no justice for the accused. That is the main problem. Thank you.
Victim interest also be taken into consideration by a learned judge at the time of imposing sentence. In the absence of sentencing policy, the judicial discretion shall be exercised by a judge, keeping in view if it is a gruesome murder or triple murder, or rape and murder, if the life imprisonment and death sentence is the punishment available for a judge, he is required to examine, yes, victim interest to be taken into consideration. But at the same time, the other aspect, under the guise of taking interest of the victim interest can be safeguarded if the accused is found guilty. He can be asked to pay the compensation. Number 1, there is a Criminal Procedure Code chapter and there are judgments of Supreme Court. Now, question is death sentence or the capital punishment or life imprisonment. Between these two, the proportionality of the crime and the punishment is required to be examined. Doctrine of proportionality is also required to be taken into consideration by a judge. So now, if it does not come under the category of rarest of rare cases as held by the Constitutional Bench in Bachan Singh case, then the next question is only life imprisonment. So for that, the fairness and reasonableness and consciously, fairly learned judge who has who is trying and who is examining the case, the first appellate court or the second appellate court required to examine and impose the sentence in the absence of sentencing policy.
And I think the whole victim rights discourse is often presented as being victim rights versus rights of the accused. And that false dichotomy that somehow we can protect victims more by taking away rights of the accused is just a false one. I mean, there are problems on both ends of the criminal justice system in terms of, we know how difficult it is to file a police complaint or a FIR or get it investigated fairly. So there is that aspect of the problem, surely. But to suggest, and as even former Chief Justice of this country have suggested, that we need to have lesser and lesser rights of the accused, I think is just misleading to say that somehow if accused have lesser rights, victims will get more justice. And I think we just need to question that dichotomy. The last question was about, you said that if we don't give the harshest punishment or the death penalty, that people will lose the faith in, could you just repeat that question?
My question was essentially if the real facts as it is today, if tomorrow, if we're going to just put it out to the world as to how faulty all the way from the legal education and from forensic evidences and how the police system works,
right,
and everything is put before the world tomorrow, and you abolish death penalty in the first headline in the newspaper tomorrow, I'm concerned with the reactions of the public,
right,
in terms of how, whether possibly they might lose faith in the real system that we really put faith on, in the constitution that we put faith
right,
on, and
right,
how is it that we're going to really, are we going to have a threat on the institution of a judiciary itself?
right.
The concerns
Got
of
it,
such
got it.
nature.
But I think I'll just take that question and say that it has to be the maturity of a democracy to deal with the realities of its legal system, right? You can't escape and say we are going to pretend that somehow these really dark realities don't exist, right? And then the question is, if these realities are true, what is the worst manifestation of that, right? And that's not, and you might, sure, we could consider the argument that he's saying, then should we even have punishment at all, right? Should we have criminal law? Should we have prisons? Sure, we could go down that reductionist line, but to say that what is the most perverse manifestation of that crisis, and I would think that the death penalty ranks pretty high up there in terms of its most perverse manifestation. And whatever else we might or might not do in response, I think we really need to ask serious questions of, is this a system in which we want to have the death penalty, right? Yeah. Can we have another set of questions? So one question at the back there, and yeah, and one question here, and one, yeah.
I have a tangential question.
So can you have your name, please?
My name is C. Venkatesh Kamath, C. Venkatesh Kamath. I have a tangential question, not direct question. You have discussed threadbare about death penalty. There are unofficial, indirect death penalty for thousands and thousands of people. You have not even touched it because it is indirect. People who are forced to suicide because of various reasons. Not only the farmers, a lot of other people are forced that you have not considered. There are other people who are suffering as if it is death penalty because certain people's properties and other things for tens of years have been taken away by the land grabbers, and they are suffering in the legal courts for years together without any relief at all. That's also an indirect death penalty.
Yes.
I'm a tangential question. It may not directly touch.
I understand.
If it time permits, you can
Sure,
answer,
sir.
or
Sure.
you can consider answers for that. That is also equivalent to a death penalty.
Sure,
The
sir.
death penalty may not be implemented. It will go on appeal after appeal. That's a different question. This one is guaranteed death penalty.
Got it.
Thank you.
Thank you, sir.
Yeah, so I'm Shivangi. I'm part of Enfold. My question is that it's a comment and a question. So the public opinion changes when there is a gap of information that is filled, that they're told that, you know, the problems with the legal system, etc. So if the same standards were to be applied to judges, since their gap of information is not that they don't know how the system is, but also if that gap was filled with presenting deterrence studies and saying that deterrence does not work, like the surety of punishment works better than the severity of it. Or to say that even abolitionist countries, so like the states in the US which are abolitionist, have the same rate of crime as the non-abolitionist countries. So if that data was presented, would then the Marshall hypothesis still apply? It's a question, and thank you.
Thank you, my lord. Thank you so much. My name is Rahul from School of Law, Christ University. I'm a first-year law student. As my lordship very well mentioned that there are certain loopholes in the system.
Keep it closer to your mouth.
Yeah. As there are certain loopholes in our system and the accused get acquitted very easily due to our loopholes. It's not about I think that it's not only in the case of death penalty, it will also, similarly it will happen into the case of life imprisonment too. So my lordship, I would like to ask you, is there any possible solution, or are there any possible solution, because you've like dedicated your entire life into the field of law, so that I don't want that system to be a subtle, but are there any possible solutions so that the system can improve?
Thank you. No, I'll just take the first question on the tangential question on suicides. I mean, I think we restricted ourselves to capital punishment because it was in the context of criminal law and the law prescribes it as a punishment. Another thing that we didn't discuss, apart from the points that you mentioned, sir, was the whole issue of encounter killings or illegal executions that the state undertakes. And during our study, we figured out that in all the conflict zones in India, be it Jammu and Kashmir, Central India, or the Northeast, the death penalty is not used, right? The death penalty is not used by the state because the state is using other methods to kill, right? Just like Israel does not have the death penalty, right? Israel does other things to have its way. So in that sense, yes, this question of death and law and how does the law or governance invoke and perpetuate suffering and death is absolutely a question for deeper inquiry, and unfortunately I don't have any deep answer to that, but I just want to acknowledge that that is seriously an area of inquiry about how law and governance inflict suffering and death in various ways, and death penalty is just one aspect of that. Absolutely, I acknowledge that. Thank you. Thank you.
Very relevant question, Mr. Kamath. Lakhs of people committed suicide. It is not a suicide. The circumstances made them to kill themselves. The accused is the state. Accused is the state. You are right. But this should be, people must come forward and file a petition, file a complaint, and it must be registered. Case must come before the court for trial and investigate and trial. Definitely the state failure having regard to the distress of a farmer not addressed. Therefore, the circumstances made them to die. That means state made them to commit suicide is a murder. That should be interpretation should be given. You are perfectly correct. That's one aspect. Second aspect is land grabber. Land grabbers also at the instance of powerful people, not common people are doing it. Slum, the owner's property, they go and occupy. They will get evicted. That's different matter. Big in Bangalore city, throughout the country, land grabbers are many. So those people also should be booked by the state. For not doing it, the executive officers who have allowed them to grab the land must be the accused person against them. Case must be registered. These kind of cases are plenty. People must come forward, file the case, and if your FIR itself will not be registered by these police people. I am telling you. So therefore, it is a very broader issue which is required to be agitated. Public opinion must be built up. People must come forward, expose all these people, then only will get justice. Third one is the cases which are pending because the infrastructure is not provided. Like any other country, if a family dispute 40 years here, we have disposed of the case of a rape within 15 days. In Uttar Pradesh, that MLA case in Ames, it is going to be decided within a month or 2 months. So it is possible to dispose of expeditiously, provided the state required. It is a constitutional obligation to provide the infrastructure. That is not done. And system must be revamped. The system, the procedure, the technicalities, all these things has to be revamped. People must cooperate it. People do not know the system, how to man it. People drag on. In this, everybody is a contributory factor for delay, and that delay is certainly causing great mental agony, hardship to the people. They are every day dying, you are right. So this is a broader issue which is required to be addressed. You have raised a very good question, not to this forum, it should be raised in the public. I am with you. I will draft the complaint for you. You can go and file a petition.
Thank you. Carolyn, you want to take the question on the deterrence study in terms of, do you think supplying deterrence information to elites, given that we're seeing that that's the basis for the support for the death penalty, will it make a difference? Or are you seeing the resort to deterrence as that it's masking something else? That this invocation of the deterrence argument is not really about deterrence? Or can we solve that by just doing more deterrence studies and supplying deterrence information? The elites will change their mind.
Yeah, I think you've asked an empirical question, and Saul and I looked at each other and said, great question. So yeah, you win the question of the night award from me. I won't win the answer of the night award, though, because I don't know the answer. But I think we should try to find out, because I think you might be onto something there. We asked in the Indonesian study I'm in the process of doing, and so I've only got pilot data to rely on. We asked the respondents about their awareness of deterrent studies and what they thought the awareness of the political elites who were making decisions about the death penalty was on deterrent study. And I think their awareness was quite low. So it could be that they're using deterrence because it sounds intuitive, and it does sound intuitive. Most people in the public would think that. My mother thinks it's intuitive. So I think that educating elites either during or prior to a study might be a nice way of teasing that out, because I think Anup's right that there could be a conflation of retribution and deterrence, but people might think that retribution just sounds wrong. I'm not going to appear to be vengeful. I'll appear to be utilitarian. I'll appear to want deterrence to work in these cases because I want to reduce the murder rate and reduce harm. That sounds less wrong than I just want them to die. But I think we just need to find more sophisticated ways of teasing this out. And I think that must be in a structured session. But I'm going to pass it to Saul because we're in the process of thinking about this.
Okay, I'm not going to answer it. I'm just going to tell you the results of a study that we're completing across 7 Caribbean countries, where we've interviewed elites, 100 elites from 7 small island states who are hardcore retentionists. and the elites, and it's not just judges, so it's across all sectors. The majority are retentionists, but they're not strong retentionists. Okay, the abolitionists strongly believe in abolition. The retentionists are somewhere in the middle. But that's not the point. The point is that when asked why, they said it's retribution. And it's very interesting. But they didn't cite deterrence. They didn't think that the death penalty had any impact on crime rates. They just think it was just deserts. You deserved to get the death sentence. So totally different findings from this particular study. But they were also asked, the same people, why they felt the government had maintained the status quo and had not moved away from the death penalty. And they said that they felt that it was the government that believed that the death penalty deterred. And that's why they maintained capital punishment. So it's very, very confused. But I think both sides, I think the answer is conflation. I really do. Yeah. I don't, they may have answered it in terms of deterrence, but I do believe it's conflation. But it's not just retribution and deterrence. I think there's a public pressure or a pressure within the judiciary as well. So I think there's lots of different factors. So I think, this is just the beginning of this research, but I think, now we've got these answers, we could really focus on this one area and really tease out and give a lot more options as to why people are in favor of capital punishment, not just simple deterrence or retribution, but there are many different possibilities, and really get to the bottom of it.
So I assume this is, sorry, what is your name? Rahul. Rahul's question is going to be the last question. We are now 30 minutes past the scheduled time. So Rahul's question, and if both Justice Gowda and Dr. Rahman could answer that, a very interesting one in saying Rahul's question is, you talk about wrongful convictions, the possibility of loopholes. It is equally applicable to life imprisonment, right? Or equally applicable to theft convictions, which might be for whatever, how many ever years, right? How far do we go with this? What is the logical end of this argument that ours is a criminal justice system, both in India and Bangladesh, that is extremely vulnerable to wrongful convictions? Why should it apply only to the death penalty discussion and not to punishment per se? So if you could have it, you and then Dr. Rahman.
Your question is very, very relevant. That is why the hierarchy of the court system is there in India. If the trial court commits an error in coming to the conclusion with respect to the charge, the appellate court must correct it. Appellate court also does not do it. Then the second appellate court, that is the Supreme Court. The Supreme Court, very, very, very difficult. They will not look into it. I looked into it and I set aside the conviction, concurrent finding. So the wrong understanding. The concurrent finding means there is no case in favor of an accused or aggrieved party. That idea, that understanding is not correct, particularly the present situation. So every case is required to be examined. You must have the patience to look into it. To see that wrong convictions are avoided, we must have good minds, in the sense abundant common sense and patience and acquisition of knowledge, know the system, know the societal nature, and your perception must be only on the basis of the record, appreciate and record a finding. That kind of judges and that kind of system you have to evolve. You hope, you are all people now, Law University, you are there. Don't go to the company. Please come to the bar, or these judges and lawyers, effectively argue, effectively decide, there will not be wrongful conviction.
So you are the solution.
No, best minds are there, not that we don't have. Best system can be evolved, provided you come forward. Judgeship is a very difficult job. Lawyer job is also a risky job. But don't go to a multinational company, please come here.
Dr. Rahman.
Yeah, His Lordship Justice has said everything. I can just say a few sentences there. We are not saying that abolition of death penalty will solve all the problems, because both the studies have bring about so many problems that requires to be addressed, and criminal justice system of Bangladesh and India probably should be overhauled. There are problems of investigation, problems in the torture, problem in other issues and sectors as well. So everything should be reformed, right? So death penalty abolition can be just be one of those items. Now question may come, why death penalty? Why not for the other convictions? Yes, if there is a wrongful life imprisonment, it may happen, it happens, and it will happen, unless we can go for some robust reform, right? Possibility is that a person would be unduly subjected to life imprisonment, but he will remain alive. That is one thing. And the second thing is that there is always a possibility of reversing the judgment. But whenever there is a possibility of wrongful death penalty, this is irrevocable. You cannot just bring back that person to life. That is why death penalty issues come prominently first. But that is not to say that abolish the death penalty and keep the criminal justice system as it is, right? So this is our first. This should be our first agenda, but there should have the other agendas to follow as well.
Is deterrent, somebody asked, deterrent punishment, capital punishment is imposed, there will be a deterrence in continuing the crime. That is only a myth. That is a wrong understanding. If that is the reason, how many death sentences have executed in India? Is the crime rate has come down? No, it is increasing. Multifold it is increasing. Why? So, deterrent punishment is no reason to avert the crime. Please understand this. Instead of deterrent punishment, we have to see that, as rightly has pointed out, that the system must be evolved to see that the sexual harassment, rape cases, all these things, why it is happening? It is law and order is a big failure. And the societal nature, how upbringing of the youth, the people. There is a flaw in the system. That system, unless you must rectify it, the crime will not come down. Please, you please watch. A fact which is not the real fact, you are projecting. Deterrent punishment is there, the crime rate will decrease, is not correct. We have to set right the whole system. That is the responsibility. The responsible government must govern the people, not only police department, judicial department. In the house, how we have to upbring the people. That is the responsibility. If they don't take the responsibility, state government must evolve how to culturally change the people. That is lacking in this country. That is why we are facing the problem. Please.
So on that very broad note on understanding nature and causes of crime, and those are very complicated discussions, and I think particularly given the times we live in today, criminal law is a particular area of concern, given what we criminalize, how much we punish, all very grave issues that we confront on an everyday basis. And some of the most fundamental protections of our democracy now just don't seem to exist, right? All seem to be under challenge. And in that context, to revisit some of these conversations and understand and reaffirm why we have these protections and why it is inherent to a rule of law society to have these protections. And I think it's incumbent upon each one of us as citizens of this country and people residing in this country to engage in that conversation. And I hope in forums like this and in all other aspects of your life, you'll carry forward those conversations. And it only remains for me to thank all of you for fascinating discussion and your comments, and for the questions, and for this wonderful participation that has really encouraged us. We are most probably back here next month for a discussion on the legal aid system in the criminal justice system, on how legal aid works in our criminal justice system, and I hope many of you will return for that discussion. And on that note, thank you once again for coming this evening. Please do join us for some tea and snacks outside, and have a good evening. Thank you.
Sorry. Before everyone leaves, if there's someone who's not registered for the event, could you please go to the registration desk and do it? Thank you.